Brown Jackson made this decision by herself last night, and we are not accustomed to seeing justices act on their own. The reason she does that is that each federal appeals court in the country has a justice that sort of acts as the circuit justice for that circuit where there are emergency applications. Usually that person will refer it out to the full court. Last night, Ketanji Brown Jackson, perhaps because of the time exigency, but also perhaps because she wanted to shape what was happening, decided this on her own. And what she decided was, I am going to let this Court of Appeals make a decision about whether or not to stay the decision to compel SNAP benefits for November over the long term as the appeal is pending. But in the meantime, I'm going to grant a very limited administrative stay for a couple of days, assuming that the First Circuit acts. And the reason I'm going to do that is because if I don't do that, you can't unring the bell. It would essentially moot the government's ability to appeal it. If she did nothing, right, then the money would have to go out the door, and the government's ability to appeal that judgment would no longer be something that they could even do. So she's granting them a very limited stay on that judgment. At the same time, I think she's trying to impose some order here. Think about this administration, and many presidential administrations, they're not alone in this, have started to leapfrog courts of appeals when they don't like decisions of district courts and go immediately to the Supreme Court for a rescue. She is basically saying, stop doing this. Go through the normal order. You have an appeals court that told you it will consider your application for a pause of that order pending your appeal. It intends to do so. It told you it would do so rapidly. Trust them. I'm going to.